We're back with the final podcast with Thomas and Tobias from Gleiss Lutz, and we're covering collective consultation issues in Germany. Thomas, Tobias, we ask you to explain the different employee representative bodies that you have in Germany and what roles they play?
Yeah, maybe as a starting point, just brief comment on the various employee representative bodies. They exist in different forms. In particular, we have the trade unions and works councils that may be of particular relevance for employers. A trade union is an organization of employees within a commercial or professional sector in Germany that represents the interest of its members, in particular by improving the payment and other employment conditions. That means that the unions in Germany are generally organized on an industry wide basis, and they only represent, as mentioned, employees who are their members. And as regards the competence of the unions, maybe one important aspect to know is that they enter into what we call so-called collective bargaining agreements, similar to what you have in the UK. As regards the Works Council, what we call in German Betriebsrat, this is a representative body that may be established in an individual company's business operation, e.g. a branch, which must have at least 5 employees. The establishment of a works council is not mandatory under the law, so it's up to the workforce to decide to elect a works council and proceed with the relevant election process. The works council represents all employees in the operation for which it is elected for, except for managerial employees, and this applies irrespective of any union membership of the individual employees.
And what is probably really important, if I may add, that as Tobias mentioned, works council are not mandatory, and in practice we have seen some very, very big company who didn't have a works council for a long time. One prominent example, for instance, is SAP, the software company here in Germany, and they had several thousand employees and got a works council, I believe, 10 years or so ago. But before that, they didn't have a works council, and the avoidance or avoiding a works council may in particular be possible in certain industries. For instance, we are both based in Frankfurt. I would say in a lot of foreign banks in particular don't see works council, even if they have, let's say, several hundred people here on the ground. But eventually, a company has no legal means to prevent the establishment of the works council. It's really about dealing with the people in a way that they don't feel that they should start to establish a works council.
Thank you. And I suppose one topic it would be really helpful to go into, because it's such an obvious kind of contrast with the UK, are sector level bargaining agreements. Can you explain a little bit about how they work?
Yeah, so as you mentioned, the CBAs, the collective bargaining agreements, typically apply industry-wide and define the employment terms and conditions for a certain industry, for instance, the metal and electronic industry in Germany. So the CBAs cover, as mentioned, the working conditions of the workforce, e.g. salary, notice period, and other matters, and have, and that's maybe a particularity, immediate and binding effect to the employment relationship of union members. So all employees in the industry who are member of the relevant trade union. However, and that's important to know, for the CBA to apply to the employees of a company, the employer needs to be a member of the competent employers association. So the association which agrees with the trade union, with the relevant trade union on this specific CBA. Typically, the bigger companies, bigger employers in Germany are member in the relevant employers association. with regard to smaller companies. So it's not mandatory to be, of course, a member in the Employers Association. Smaller companies sometimes refrain from entering into membership, but and that's maybe also a relevant aspect. Even if they are not a member in the Employers Association, companies sometimes decide to apply the industry applicable terms and conditions, at least some of them, to the workforce in their company.
Yeah, the reason being that, you know, the CBAs define a certain, let's say, salary level or a certain level of terms and conditions for employment in an industry, and you may just not be able to attract people as an employer if you're not offering at least similar employment conditions. But as Tobias said, it's not mandatory.
Yes, that makes sense. I can see that if you are trying to compete in an industry in Germany, you and all of your competitors offer a particular set of terms that you'll be under pressure to hire talent. You'll need to know what those are. So I think that's very helpful to hear about. Can we skip to a different topic, which is we often hear about co-determination rights when we are dealing with matters in Germany. Could you explain what they are and why employers might need to understand them?
Yeah, co-determination rights relate to rights of the Works Council. Yeah, when we are talking about co-determination rights, it typically relates to the Works Council, i.e. not to the unions. And the rights of the Works Council are stipulated in the what we call Works Constitution Act, which contains rules on the establishment of Works Council, but also their rights. And the rights of the Works Council are, you know, very far-reaching. They start with information rights. Yeah, the Works Council, for instance, is entitled to receive information which it requires to check whether the company complies with legal obligations. Yeah, for instance, working time. Yeah, if the Works Council wants to check whether the company complies with working time requirements, the Works Council can ask the employer to be provided with information on the actual working time of the employees in order to check whether the legal requirements are complied with. The next type of co-determination rights would be a consultation right, as we would call it. In such a scenario, the Works Council can express its views and, you know, can say, you know, we have different ideas. And the company, the employer, must engage with the Works Council in such consultation and must take any comments from the Works Council seriously, must respond to them. But such consultation rights of the Works Council are not, let's say, that does not mean that the Works Council would have to approve certain measures. And maybe the last and most important ones are the real co-determination rights, which are basically rights of the Works Council, which, you know, require the company to get the approval of the Works Council before implementing certain measures. For instance, the Works Council has a co-determination rights in relation to the allocation principles of bonus schemes. Just to give you a very specific example, yeah, the employer can decide, you know, my bonus pool is the amount of X, but how the amount is distributed between the different employees is really something the Works Council has to approve. And what we see in practice, for instance, is that the company would agree with the Works Council in a written agreement on the, for instance, allocation principles for a bonus, and that would be what we call works agreements, Betriebsvereinbarungen. But such a formal agreement is not legally required. It would also be sufficient if the Works Council just approves the approach of the company, basically saying yes, we agree to this. And these different types of, let's say, co-determination rights can really play, or can play or different types of co-determination rights can play a role in a specific project. For instance, if you're talking about a mass redundancy, just to give you an example, the Works Council basically has only a consultation right on the measure itself. So, say the company decides, we want to eliminate 10% of our workforce. It has to engage in a consultation process with the Works Council, but eventually the Works Council does not have to approve the cut of the jobs. Typically, in such a mass redundancy scenario, also what we call social plan needs to be negotiated, i.e., an agreement which provides for certain termination benefits like severance pay and the like. And in relation to this social plan, the Works Council has a co-determination right, which means the Works Council can force a social plan upon the company. And as I said, the Works Council cannot prevent the job cut, but it can define the determination conditions by forcing a social plan. And these co-determination rights really play a very important role, because the Works Constitution Act gives the Works Council a lot of rights in relation to very different topics, as I mentioned, working time, general rules of order in the operation, principles for vacation, remuneration principles. So it's really far-reaching, and the Works Council really has a say in a lot of items. And you may probably wonder, how you resolve a conflict, if the Works Council just does not agree. And Tobias wanted to make a few comments in this regard.
Yeah, so in case there is a real co-determination right, i.e. the employer may only implement a measure after the Works Council's consent, both parties, so the employer and Works Council, will start an information process and then enter into negotiations. And in case they cannot find a mutual solution on the intended measure, there is under the law some kind of, let's say, escalation mechanism. Both the employer and the employee may apply for a so-called arbitration board, and such arbitration board consists of the equal number of representatives of the employer side and of the Works Council side, and in addition there is a neutral chairman, sometimes a labor law judge, sometimes already retired. So there are more or less professional chairmen for arbitration boards in Germany. And this chairman serves in the arbitration board as some kind of mediator, and the parties, so the Works Council and the employer, just continue the negotiations together with the chairman in the arbitration board. Sometimes they find a mutual solution and an agreement, then the process is finalized and the employer may implement the measure based on the agreement. If they cannot find a solution, the chairman is the one who makes the final decision on the intended measure in the end. As regards to process establishing the arbitration board, that can be done mutually. So the Works Council and the employer can agree on the number of representatives and the chairman. If this is also not possible, both employer and Works Council may apply to the labor court and ask the labor court to establish the arbitration board and decide on the chairman. And after the arbitration board process, i.e. in case there is no mutual agreement, but rather a decision by the chairman, such decision may also be reviewed by the Labor Court later based on an application both by the employer and the Works Council.
If you hear this process, and sometimes that's the response we get from our clients, you may say, well, that sounds like a nightmare. And my counter argument is, well, look, the German economy is doing quite okay, also in comparison to other countries. But the point I wanted to make here is that it's really important to understand that to deal with those co-determination rights, to deal with the Works Council, really has a cultural aspect as well. If you were just looking purely at the law, you would say, you cannot run a company here in Germany because based on the law, the Works Council has so many rights and can make the life of a company basically, or for management, miserable. And that's true. But culturally, I would say German Works Council tend to aim, let's say, on compromises. They are trying to find reasonable solutions. So it's not a very contradictory relationship usually between management and Works Council here in Germany, for instance, like in France, as you sometimes hear, or in the UK or in the US, at least, where you really have fights between management and unions. Sometimes we have, but the vast majority of our Works Councils have a decent working relationship with their management. And in order to maintain this, you really need to take them serious. You have to accept that they have certain rights, and if you don't do it, you really may run into problems. And one very prominent example we had here in Germany was the retailer Abercrombie and Fitch, and apparently they decided, to do it, the way they were used to do it in the US worldwide and also in Germany. And if you look at the workforce of the Abercrombie and Fitch stores, all those young, good-looking people, you wouldn't say, well, that's not a typical bunch to elect a Works Council, but they were able to manage that the employees elected Works Councils in their stores here in Germany, and there were really big fights between the Works Council in the stores and the Abercrombie management. And my sense, just from the outside, it's always easy to make comments from the outside, but my sense is that they were just not accepting that things may be done differently here in Germany, that Works Council employee representatives have certain rights and that you have to take them serious. And if you don't do it, then you may really run into serious problems, because the law gives the Works Council a lot of angles and a lot of leverage, to force their position.
Thanks for that. That was really interesting, and I think it definitely is quite different to in the UK, but obviously really highlights the importance of understanding the employment law landscape and what you're getting yourself into when you're working in Germany, and presumably it's obviously the importance of kind of having a good working relationship with your Works Councils. Well, that wraps up our series with Thomas and Tobias. Thank you both so much. It's been incredibly interesting. If you have any queries on the topics that we've discussed during these podcasts, please do get in touch with us or Thomas and Tobias. We'll be back next month, so please do check in to find out who we'll be speaking to.